Bearing Arms editor Cam Edwards on the DOJ attacking DC's AR-15 ban while defending the federal Switchblade ban. That and more on this episode of the Weekly Reload podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and sign up for our free weekly newsletter today if you want to keep up to date with what's going on with guns in America. No news update this week because the holidays. And so we are still, though, doing a interview podcast. And this week we are going to be talking with Cam Edwards from Bearing Arms about the Department of Justice and some of the interesting moves that they made. I mean, first of its kind move in DC, a lawsuit that they filed there. And then on the same day, a seemingly contradictory move defending a federal law. And then as well, we'll discuss a little bit about why Cam is on the show instead of the Grab a Gun CEO that was supposed to be here this week. But first, let's welcome Cam back to the show. Thank you so much for being here, Cam, on short notice. I appreciate the help.
Yeah, absolutely, man. Anytime. Love coming on and talking with you.
Same here. Love having you on. But yeah, let's start off with the biggest news of the week, which was the Department of Justice, the Civil Rights Division's Second Amendment section. The name is getting longer now. But they have filed their second lawsuit. And this one, I think, is going to get more attention than the first one, perhaps, which was in the U.S. Virgin Islands. Still a pretty substantial lawsuit there. But this one is in Washington, D.C., and it deals with what I think for gun rights advocates is perhaps the holy grail, a challenge to a Second Amendment challenge to the city's assault weapons ban. Can you give us just a little bit of background of what exactly happened? With this?
Yeah. And I'll just note that while this is the DOJ Civil Rights Division Second Amendment section's second lawsuit, before the Second Amendment section was created, the Civil Rights Division had also filed suit against the Los Angeles Sheriff's Department over delays in concealed carry licenses. So this is, I guess, technically the third lawsuit filed by the Civil Rights Division dealing with Second Amendment issues. And as you say, I mean, this is historic in that it's the first time that we've seen the DOJ. They've argued before the Seventh Circuit that state level bans on AR-15s are unconstitutional. But this is the first time that they're taking the lead in litigation here, and not just participating in oral arguments, not just filing amicus briefs, but actually, being the ones to file the complaint against the Metropolitan Police Department. And I think it's really interesting. I also think the Virgin Islands lawsuit is pretty interesting just because, when I spoke to Harmy Dillon earlier this week, she made a point of saying that the Second Amendment applies in U.S. territories just as it does in the states, but also some of the egregious nature of the Virgin Islands gun laws, which are even more draconian than what you'd find in California or New York. But, in terms of the DC semi-auto ban, it's interesting to me. Obviously, we've got other, Second Amendment cases around the country. 2A groups have filed similar lawsuits taking on, bans in California, New York, New Jersey, Illinois. So you could argue, I guess, that maybe the DOJ is replicating earlier efforts. You can make the same argument, I guess, with the lawsuit against the Los Angeles Sheriff's Department, given that California Rifle and Pistol Association, several other groups had already filed suit against the LASD and several other jurisdictions. But this is a unique jurisdiction, right? So this isn't DOJ just piggybacking off of 2A groups. This is them doing some, original legwork. And what's going to be really interesting to me is, this ban has been litigated before, right? I mean, this was the Heller 2 decision, I believe.
Dick Heller himself has filed a suit against this same law in DC, and his suit, Heller 2, they called it, and I think there was a Heller 3, and so Dick Heller has been a very active litigant in Washington DC. Oftentimes he's had success, not just in the most famous example in 2008, the handgun ban, but also in later regulations on gun owners in DC here. But in Heller 2, in the case against the assault weapons ban, he did actually fail at the panel level 2-1 decision, with the one dissenter being actually Brett Kavanaugh, the current Supreme Court justice, which is one of the things that has given us insight into how Kavanaugh is likely to vote at the Supreme Court as well on this question. But regardless, that actually brings up an interesting point, because as you've laid out there, that none of these suits are really new concepts, right? Not that they need to be successful, but they do have the backing of the Department of Justice now, which is not something we've seen before. And so I wonder, DC specific here, do you think the Department of Justice is better positioned, maybe as an institution with more resources than Dick Heller, random DC resident? This is essentially what he is. Or do you think perhaps they're better suited in the fact that the law has changed significantly since the Heller 2 decision was handed down? Given the fact that Kavanaugh wasn't even on the Supreme Court at that time, you didn't have Bruin, for instance, at the time that Heller 2 was decided. What do you make of DC's the DOJ's arguments? Don't seem to be all that different from what you see in these cases, but do you think they have represent a better case here?
So I do think that the DOJ bringing suit gives this some, institutional heft, right? That doesn't have when Dick Heller or even groups like the Second Amendment Foundation, Farms Policy Coalition, GOA, or NRA file a lawsuit. The courts tend to take a little more notice, rightly or wrongly, when it's the federal government, right, intervening here. So I think that the short answer to your question is yes and yes. I think that this does give some more weight to previous challenges, and I think that as you say, the makeup of the D.C. Circuit Court of Appeals has changed. The makeup of the Supreme Court has changed since Heller 2. But I also think that getting back to Justice Kavanaugh, he said after the Supreme Court denied the cert in the Snopes case, he expected the court to revisit the issue or to visit the issue and take up a hardware ban case within the next term or two. So when the court comes back for its first conference in 2026, they're going to have two magazine ban cases in front of them. Gators Custom Guns versus Washington, Duncan versus Bonna. They're going to have a semi-auto ban case in front of them, Viramontes versus Cook County, Illinois. They could take either of those cases, kind of waiting in the wings. There's the challenge to Illinois', not just Cook County's ban on so-called assault weapons, but Illinois' ban on so-called assault weapons. We're waiting for the Seventh Circuit's decision. I think everybody kind of expects the Seventh Circuit to uphold Illinois' law. We're still waiting on the Third Circuit to issue its ruling in the challenge to New Jersey's ban on so-called assault weapons and large capacity magazines. And there, I think the expectation there is that the Third Circuit is going to find issue with New Jersey's gun and magazine ban. So I'm at the very least, I think the DOJ filing this lawsuit against DC is a signal to the justices on the court that, okay, we're interested in this. And, maybe sooner rather than later, the Supreme Court needs to take up this issue. So, if the Supreme Court were to wait until the DOJ's lawsuit gets litigated, I mean, we're going to be waiting more than a term or two, right? We're talking probably, 3 or 4 years before this case would get up to the Supreme Court. But there are going to be opportunities for the court to address this earlier, and I don't know if they're going to wait for a circuit court split to maybe develop with the Third Circuit, or if they're just going to go ahead and take one of these cases that's in front of them now. I'm not a fly on the wall. I'd love to be have some inside information what the court's going to do, but I do think that this. I don't know if it applies pressure to the court, but it definitely again signals interest by the DOJ and the Trump administration that, hey, we think you should take up this issue too, because we think there's a problem with these bans.
And the court, I will say the Supreme Court has seemed to take notice of DOJ getting involved. That's the Wolford case, the Hawaii case, the gun carry case, was something that DOJ intervened to say, we think the court should take this case. And then they did. Now obviously they have also filed those amicus briefs in the other assault weapons ban cases. So they kind of perhaps already covered the base on that front. One thing I do find interesting here, I guess two things, right? One is I get the arguments are similar in terms of why the assault weapons ban is unconstitutional, right? It violates the Second Amendment. These are commonly owned firearms for lawful purposes. Similar stuff to what we've seen in pretty much every assault weapons ban challenge. I guess the one unique aspect of it, though, because it's the DOJ filing this and not, just individuals or groups on behalf of their members, is that this involves a pattern and practice claim here. So they're claiming that the MPD has been involved in a pattern of practice of denying the Second Amendment rights to DC residents by not allowing them to register under the city's gun registration law certain kinds of firearms like AR-15s and other semi-automatic firearms that are the DC has your more traditional 90s era to feature assault weapons ban. Semi-automatic rifle that can accept detachable magazine and has two or more of a list of features like pistol grips and telescoping stocks and handguards. So pretty traditional assault weapons ban in DC. They haven't really done all these updates that places like California and Massachusetts have done. But regardless, like, it's a little bit different tactic here. Do you think maybe that gives them a leg up as well over some of these other challenges? Or at least it's something tactically a bit different. I don't know.
It is, yeah. I mean, well, it is tactically different, right? And I don't know if it gives them a leg up, but it gives DC an out, I guess. Although I don't think it's an out that the DC City Council is going to take, right? I mean, yeah, the MPD, for better or for worse, is applying and enforcing law that the DC City Council and the
Right.
mayor,
Yeah.
approved, right? So
The MPD is
the Metropolitan Police
they're
Department,
required to do
right.
these things, but yeah.
So, I suppose the city council could say, all right, well, if we want to get out of this lawsuit, then we can, revise our statute. I don't think they're going to do that in the slightest. I don't think there's going to be any interest on the council to do that. But, I don't know. I mean, again, when you're talking about a pattern practice lawsuit, then you're typically talking about, a consent decree where the Metropolitan Police Department would agree to operate under certain conditions, which case this would be allowing people to register those guns that they're not allowed to register right now. So I mean, it's interesting, maybe again from a tactical standpoint, but I don't think, or maybe from a strategic standpoint, but I don't think it's going to matter much in terms of how this case ends up, or even how this case is argued going forward.
And the other part of that too is I've seen it suggested by Rob Romano, who works for Firearms Policy Coalition, great resource on X.
Absolutely, one of the best.
Yeah, always up on whatever's happening with gun litigation out there. But he suggested that there's sort of there's thought put into why the DOJ is doing these particular cases, these three cases. LA had the longest wait time complaints that we've seen. Virgin Islands had some of the most significant restrictions still on the books. And then DC, he suggested that there's been an issue with standing for gun rights challengers there, which is true, right? That we've seen a number of cases, especially like the Metro gun ban. So in DC, even if you have a permit, you can't carry on Metro. But several courts have thrown out challenges to that because they're saying, unless you actually get arrested doing this, which, by the way, MP never has, I don't think they've ever arrested anyone for carrying on the Metro without a permit or with a permit. And so you can't get standing. It's harder. It seems like DC's circuit has a higher bar for getting standing. And so maybe that's part of what happened here. And maybe that will give them more success in the long run in this challenge. I don't know. What do you think of that?
I mean, it's going to be, I think, harder to dismiss for lack of standing, right? Because the federal government certainly has a vested interest here. In fact, the federal government, technically has oversight over DC law, or Congress does. So, there's an argument that that the federal government has a vested interest in ensuring that DC law is compliant with the Constitution. And I think Rob pointed out too. I think one of the other interesting things about the Virgin Islands lawsuit is that the Virgin Islands, if I remember correctly, is under the jurisdiction of the Third Circuit Court of Appeals, which has kind of shifted to a pro-gun majority, or at least we think it's a pro-gun majority. And going back to like Range versus Garland, Third Circuit held that, just because someone was convicted of an offense punishable by more than a year in prison, that doesn't mean they should automatically lose their gun rights forever. They've taken a position with 922G3, the unlawful use of drugs, that there needs to be some nexus between somebody's dangerousness as a drug user and their ability to own a firearm. Again, the New Jersey assault weapon and magazine ban cases that the Third Circuit heard, a lot of indications during oral argument that that the court is going to find at least some fault with New Jersey's law there. So it's a friendly jurisdiction as well as some really egregiously awful gun control ordinances. You've got to have a certain kind of safe. You've got to have it mounted to the wall in your home. You got to allow the police to come in and inspect that safe and your firearms. Pretty low hanging fruit, I guess, when it comes to Second Amendment violations. But at the same time, these are laws that are still being enforced, right? So they should be challenged.
And it's in a jurisdiction. This is what I thought. You made an interesting point earlier about like how much. Yeah, this DC lawsuit is probably going to get the most attention of these because it's surrounding the assault weapons ban, and it's the DOJ challenging an assault weapons ban, which has been the thing that gun rights advocates have wanted to see struck down for forever. Obviously they want to see the Supreme Court strike it down, but still it's I think going to get the most attention. But I wonder if that Virgin Islands case isn't a better example of how useful the DOJ Civil Rights Division getting involved could be, because you're not going to have a lot of lawsuits in the Virgin Islands because there's not a lot of people live there, not a lot of groups are going. I mean, even getting Hawaii lawsuits is hard. You really just have one guy, Alan Beck, kind of spearheading most of the legal action out there. And these places kind of get put to the wayside because they're, the gun rights groups have far fewer resources and they have to focus on areas where more of their members are affected, or they think they're most likely to, be able to win the case or what have you. And I do wonder about that.
And the Virgin Islands has had some standing issues too. So there really hasn't been a Virgin Islands specific Second Amendment group until very recently. I think now there's a Virgin Islands responsible gun owners. I think it's a gentleman named Kosi Ano who started that, and he had filed suit a couple of years ago. I hope I'm getting all the details right, over the gun licensing procedure. Kosi kind of splits his time between the Virgin Islands and the state of Washington. And Virgin Islands had basically said you don't have standing to apply for a Virgin Islands, gun permit because you don't have a Virgin Islands driver's license. And so again, standing issues came into play there. It is. I think it is useful and beneficial, certainly for the DOJ to take these supportive positions of existing litigation, but I think it also is very useful for them to take the lead in places where either Second Amendment groups have had trouble getting individual or organizational standing, or jurisdictions where again there's just this sort of dismissive attitude towards individual plaintiffs. The Izaguirre case dealing with right to carry on the DC Metro. So I think all of these are positive developments when it comes to our Second Amendment rights. I'd much prefer a DOJ that is fighting to defend our right to keep our arms, however imperfectly, than one that is just entirely hostile to our right to keep and bear arms, which has been the case for the past few years.
And going back to the DC case for a second, you alluded to, obviously people want to see this at the Supreme Court, and perhaps one thing I wonder about too is like the emergency docket. The Trump administration has been not shy at all about trying to use the emergency docket to advance their interests in federal court. Now I don't know if like a civil rights challenge to a law that was instituted in the 90s, whether you can get that up to the court in a successful way on the emergency docket, because the Trump administration has had most of its success at the Supreme Court on the emergency docket this year. That's not, they haven't always won, but they seem to be pretty adept at understanding when the court is likely to side with them, at least on an emergency basis, to issue a stay or something like that. I don't know do you see any reason to think that this case could follow that pattern?
I mean, I guess they could always try, but I think that I think the court's likely to say, look, there's a difference between you asking us if this person can be deported or if this person has to be brought back to the United States after they were deported. versus whether somebody can buy a gun in DC when they haven't been able to for the past 30 years, right?
Yeah,
Uh,
that's what I would think. And it's about like the exercise of the president's power. It's not really what this case is about, right?
right. So, I mean, as much as I love to see the Supreme Court, address this issue with some urgency, I'm just not convinced that that just because the DOJ is now involved in this litigation, that the court is going to. I think they may give the issue more importance. I'm not sure that they're going to give it any more urgency. If
And
that
they've seemed pretty reluctant to do gun cases on the emergency docket to this point, right?
Yeah, I mean, yeah, certainly on the emergency docket, Wolford versus Lopez is up there on the basis of a preliminary injunction. It has not been decided on the merits, so that's kind of unusual. But it's not necessarily. It wasn't on like the rocket docket or anything like that. So
Right. Yeah. And because we've seen like uh that first Bruin response law in New York in Antioch, that case
mhm.
got up to the Supreme Court pretty fast after the lower courts didn't issue the preliminary injunctions, but the court was it didn't want to get involved at that point.
Yeah,
I mean, we got that statement from I think it was what Justice Alito
mhm.
that more or less said, we're going to let the lower courts do their process, and then we will intervene if we think it's absolutely necessary, but we're generally going to keep with the normal schedules. What That's the impression that I got from what he was saying, at least.
Yeah,
And they seem to have stuck to that because that case still hasn't made it back up to the Supreme Court yet on
yeah.
the
Although it's
merits.
getting close, I think.
Yeah, yeah.
Um, yeah,
But it's been 3 years now, so not that that's in court time. That's not a long time,
right.
but it is. It's not. The President Trump issues an executive order, and then in a couple months, it's at the Supreme Court. Like that's very different situation. And I don't know that there's, even though that's happened quite a bit in this second Trump term. I don't know that this particular case doesn't seem like it's a candidate for something like that.
Yeah, I suspect you're right. Yeah.
But overall, I mean, seems like you think there could be some advantage as far as like eventually getting the Supreme Court. Maybe the court is more apt to take a assault weapons ban challenge from the federal government than they are, otherwise here. And it would fit kind of in that framework that Kavanaugh laid out when they denied the Maryland assault weapons ban challenge, because he said, a couple terms, in a couple
Right.
terms, we'll take this. And now there's a lot of other cases in front of this one that they could take, but
Yeah. I mean, I have to say, like, I'm happy that the DOJ has filed this lawsuit. I hope that this is not the case that the Supreme Court takes, because there are other cases in front of this litigation, and I think the court should, resolve these cases at the first opportunity. I'd love for them to take Duncan and Viramanes, even if they don't wait around for the Third Circuit case. But if they decide to at least hold on to those cases, that I certainly hope that the New Jersey gun ban or the Illinois gun and magazine ban will, get the interest and the support of at least four justices, and the Supreme Court will take one of those two cases.
all right. So that's the news of the week from the Department of Justice that has made gun rights advocates very happy. Um, However, there was another bit of news dropped the same day, another legal filing, this time a brief in a case against the Federal Switchblade Act, which is not a law that we talk a lot about, but one that is where the arguments made in this brief have, I think, pretty significant implications. But the DOJ came out and defended that act on the same day that they filed suit against DC's assault weapons ban. And yeah, what do you make of that decision? Their decision to go in and defend this. It bans the carry of automatic knives or switchblades in certain places, right? And
Yeah.
the DOJ is saying it is constitutional.
Yeah. So, one of the things that I would love to get like a direct, firm, unequivocal answer on is their coordination between, the U.S. attorneys that are, responding to a lot of these lawsuits, the NRA Civil Division, which is, kind of overseeing these cases, and the and the DOJ Civil Rights Division, right? Because I asked Harmy Dillon about this,
Yeah, you
and
just had her on your show, right?
I did, yeah. She was on the show, I believe, on Monday. Yeah, Monday, I think it was, maybe Tuesday.
And she's really the figure that's been overseeing a lot of the pro-gun litigation
Right.
from the DOJ, the Civil
Yeah,
Rights
she's the
Division,
assistant
Second
attorney
Amendment
general.
section.
She's the head of the civil rights division. She's definitely, the point person in the administration when it comes to, to a legal cases. And she did not delve into too many details, but she did say something like, I'm paraphrasing here, like they don't call me up and check in with me before they file every brief or anything like that. So I would like to see a more coordinated effort between the civil division and the civil rights division here, because I think what we are seeing, there are a couple of dynamics, right? There's that dynamic of the DOJ going after state and local gun control laws while defending, to one degree or another, every federal gun control statute out there. I think the one exception to that maybe is gun bans for 18 to 20-year-olds. They've kind of just taken the position of, let's not talk about this now. Let's kind of kick that can down the road a little bit.
Right.
And even on 922G3, the unlawful possession of guns by, or the possession of guns by unlawful drug users, there was a challenge out of Florida. This was the case that was filed by Nikki Freed and some others about, medical marijuana use. The 11th Circuit Court of Appeals, District Court dismissed the case. The 11th Circuit Court of Appeals came back and said, no, they should be able to argue this because the government hasn't shown a historic tradition of banning gun use by marijuana users. DOJ did not appeal that decision to the Supreme Court. So the case has been now remanded back to District Court. That trial's not been held on the merits, but they did not decide to appeal that preliminary stage ruling by the 11th Circuit. Which I think is interesting. But for the most part, they're defending the NFA by arguing that it presents a modest burden, even when the items in question are protected by the Second Amendment. And then with the Federal Switchblade Act, the brief, which was not filed by the Civil Rights Division, kind of explicitly said, we're talking about automatic knives. We're not talking about every knife. We're talking about automatic knives. But and one of the statements that they made was that the Second Amendment does not protect concealed carry or concealable firearms.
Right. Or weapons.
And
Yeah.
yeah, and I gotta say, like it's true that the Supreme Court in Heller, going back to Heller, Antonin Scalia, talked about a lot of 19th century laws um, that he kind of said, seemed to be in compliance with the Second Amendment where concealed carry was banned.
Mm-hmm.
But open carry was allowed, right? And even in Bruin, the Supreme Court didn't explicitly say, hey, concealed carry is allowed. What they said is public carry is protected by the Second Amendment. They didn't talk about the manner in which that arm is carried. Presumably, a state could ban concealed carry, but they would have to allow open carry. Or, vice versa. You could ban open carry, but you got to allow concealed carry. But you have to allow people to carry in some form or fashion.
Yeah.
So I guess technically you could argue, I would not argue that the Second Amendment doesn't protect concealed carry. What I would argue is that the Supreme Court has not explicitly said that concealed carry is guaranteed by the Second Amendment. But public carrying of arms is, right? And I think that absolutely includes arms that can be concealed, because the Supreme Court has held that, publicly bearing arms, in this case, New York's licensed, which specifically is limited to pistols, that had to be a shall issue license, right? So that tells me that, okay, concealable arms like pistols are in fact protected by the Second Amendment. So
Yeah. And of course, Heller as well, right? Heller was
right,
all about
handguns can be banned in the home. I mean, those are, and again, we're talking about weapons that could be concealed. So I think, even if the DOJ Civil Division was getting a little cute with its description about, the Supreme Court's views on concealed carry, maybe adhering to the, letter of the Supreme Court's decision, not necessarily the spirit, I think their argument does fall apart when they try to claim that the Second Amendment doesn't protect concealable weapons, because I think it
right.
very
Right.
clearly does.
Yeah. Let me read a quote from the brief here. The DOJ wrote, The Federal Switchblade Act is a constitutional regulation that operates on the configuration and mode of a switchblade's opening. The statute does not broadly negate the right to keep and bear arms or even any right to keep and bear knives. Instead, it merely requires that knives, or at least those switchblades sold in interstate commerce or possessed on federal and tribal land, operate in particular ways, either by having a fixed blade configuration or by permitting the blade to open only through manual rather than automatic mechanisms. As a restriction on the mode of operation, the Federal Switchblade Act is unlike, for example, the law that the Supreme Court held unconstitutional in Heller, which was a complete prohibition on handguns, the most popular weapon chosen by Americans for self-defense in the home. So they're trying to make a distinction there. But additionally, they argue that switchblades can be banned because they are, quote, uniquely suited to criminal use, and that they are inherently concealable because I have a switchblade here for demonstration purposes, because the blade is hidden inside of the handle of the knife. Now, I don't know about you, but that's also describes every pocket knife has the blade hidden inside of the handle. Now, not everyone opens with a spring assist like a switchblade does, but um, I don't know. It's some of those arguments. They're definitely trying to cordon it down to just, oh, this is only regulation of carry of a specific kind of knife, and so and those knives are particularly dangerous because they're suited for criminal use. But the arguments they're using there, one, they seem like they could apply to any knife that
Right.
where the blade fits in the handle. And two, they're very similar in my view, at least. I'm interested in you. It seems to me like they're extremely similar to how a lot of assault weapons bans have been justified over the years. This idea of unusually dangerous guns, and that certain features of that are on an AR-15. The feature-based ban, as we talked about earlier, DC has a feature-based. It bans certain kinds of features. It doesn't ban all guns or all semi-automatics. It bans kinds that can accept a detachable magazine, or they have a pistol grip or whatever. And that's very similar line of reasoning, it seems to me, to this defense that DOJ is using for the Switchblade Act.
Yeah, I think you're right about that. And the dangerous and unusual. It's not unusually dangerous, right? I mean, the test is dangerous and unusual. So
Right.
you can argue, I suppose, that
which is another language thing we've seen from people who defend assault weapons bans.
Right.
They won't say they're unusual and dangerous. They will say they are unusually dangerous, which is what we're seeing here. Or they're crafted for criminal use. It's a very similar argument you're getting from DOJ in this case.
Yeah, which and again, I mean, when we hear that phrase applied to AR-15s, I mean, again, AR-15s are used in a very small number of violent crimes, right? The vast majority of AR-15 owners lawfully possess them and use them for lawful purposes. I don't know what I confess I'm kind of ignorant on the number of Switchblade owners in the country, but I mean, the Federal
Question.
Switchblade Act came out of the 1950s, came out of the idea of juvenile delinquents using automatic knives. And we got to do something about juvenile crime. In a way, it was very much a precursor to the Gun Control Act of 1968, which kind of got started in the early 1960s, even before Kennedy's assassination, and was originally the scope was about trying to prevent juveniles from acquiring handguns. That was kind of the scope, and then it kind of blew up into the Gun Control Act of 1968. So I think that the I think the issue here, the big issue is, as you say, what's the difference between an automatic knife versus a gravity assisted knife versus a pocket knife where you've got to open it up. I don't have a switchblade here, but I do happen to have this. So, that knife,
that versus
your hand, right?
Versus this.
So what's the difference? If you close that and I close this, the blade is concealed either way, right? So
mine looks cooler, I will say that. For those listening,
right.
Mine has an American flag with the P-51 shark mouth thing on it, because this is like a cheap Chinese knife that I got from the gun show, and I
Even
use
cheaper.
it
I
as
got
a.
this for free somewhere, so I can't remember. My desk and home are cluttered with free knives that I've acquired over the
I
years.
don't think this would work as a self-defense knife in any realistic way, but it makes for a good fidget toy and letter opener, so that's why I have it.
But so I mean, again, it gets back to are knives in common use? I think so. Are arms, are knives bearable arms protected by the Second Amendment? I think so. So now you got to parse it down, right? Like, how specific can you get? Can you ban switchblades while allowing gravity-assisted knives? Can you, or does this apply, to the rules that apply to, the Federal Switchblade Act? Could they be applied to other, related weapons as well? And I think as hard as the DOJ tried to limit their language only to switchblades, I don't think you really can do that because, as you say, when you're talking about, basically any foldable knife or any knife where the blade is concealed to one degree or another within the handle or okay, that's a concealable weapon, right? Or that's a concealable or concealed blade. And then the question becomes, well, how fast can you open it? Which again kind of goes back to the argument about assault. Well, how
We've
fast can
heard
you
these
fire?
arguments
Right?
before, yeah. We've heard this.
Fire. Some automatic firearms are just they're just like machine guns. So if an AR-15 is just like a machine gun, well then is a gravity assisted knife just like a switchblade? Is this knife just like a switchblade? So this is why again I'd love to see some additional coordination on Second Amendment issues between U.S. attorneys around the country, the Civil Division, and the Civil Rights Division. And I think maybe they should be checking with the Civil Rights Division before they file their briefs.
Yeah, I mean,
Civil Rights Division has, a limited number of staff and they've got their own work, but I think that there needs to be some review. I don't think this should be just left up to the U.S. attorneys in the field. I think that there needs to be somebody checking in with Washington D.C. and Maine Justice and saying, okay, what's our position here? Because we've seen, like in Peterson, the suppressor case, DOJ had to go back and say, all right, now we changed our mind. We do believe that the Second Amendment protects suppressors, and then they went on to argue
right.
that. But you can regulate them under the NFA anyway.
Yeah, and I think that was another great example of this strange dichotomy that's evolved at the DOJ, where the Peterson brief and then these two filings on the same day really emphasize this position where they are okay with going after state regulations, state restrictions. I mean, the Peterson brief, the only implication is really 4 states that have total bans on silencers and suppressors, because the DOJ's position in that case, what they changed it to was they're protected, but only in sort of they're under the umbrella of the Second Amendment. They're not arms themselves. They're accessories that help you carry out the right to keep and bear arms, and so they enjoy some protections. But the NFA is not an infringement because it's not a total ban, and so only under that logic, at least, only a total ban would be an infringement. And the only places you see total bans are in a couple of blue states. And so, yeah, and then you look at this case where it's like, or this, Monday, I think, is when these filings both came out. And on the one hand, DOJ is saying that the argument that ARs are unusually dangerous because they have these additional features is not doesn't comply with the Second Amendment because ARs are in common use and they're popular for lawful purposes. And then the same day, they're saying in a different case, actually, this federal law that is constitutional because it bans these certain kind of knives because of the features they have that make them unusually dangerous. And it's a very, seems to be crystallized. It's almost like it's on purpose at this point, but I don't know if it is. It feels more like
I don't know that it
it
is
feels more
either.
like freelancing on the part of I get, I don't know. You could look at it either way. It feels like freelancing on the part of somebody like Harmeet Dillon, who seems to be genuinely an advocate for gun rights, or Robert Leiter at the ATF, for instance, another,
Yeah.
administration official was appointed by, this administration, so they get credit for the stuff they're doing, but doesn't feel cohesive, I guess is kind of like what you're getting at.
Yeah, but I don't know if I'd say that it's Harmeet Dillon who's doing the freelancing. I kind of think it's the opposite. I kind of think it's the U.S. attorneys out in the field. I think it's fair to say.
Could be the other way
I
around.
mean,
Yeah.
look, there's been a lot of personnel churn at DOJ is a very nice way of saying it, right? You've had an exodus of a lot of career prosecutors. A lot of U.S. attorneys, got removed when Donald Trump came into office. And there's been, problems confirming some of them. So you've got acting U.S. attorneys, and I don't know. I guess I don't know how good a handle Pam Bondi has on these U.S. attorneys who are out in the field, and I think that may be where you're getting some of the freelancing going on. Is that Harvey Dillon made it clear that even within the Civil Rights Division, there are a lot of attorneys, some of whom who are no longer employed by the DOJ, but some of whom are still there, who don't really think the Second Amendment is a civil right. And so if that's the case within the Civil Rights Division, you can only imagine that there are a lot of U.S. attorneys who, have this knee-jerk position of we're going to defend federal law because that's what we do. We don't fight to overturn federal law; we fight to keep it in place. I would argue to those individuals that the Trump administration, if nothing else, has shown a willingness to break things. It doesn't matter that something is institutionalized. If the Trump administration or Donald Trump thinks it's wrong, we'll rename the Kennedy Center. What the hell? And we'll tear down the East Wing. We'll build a new ballroom, right? So, I mean, if that's the guiding philosophy of the president, then I don't think there should be this knee-jerk reaction of, well, we have to defend every federal law dealing with firearms.
Well, and I think that's a good point in the sense that, like, under most other administrations, you could use the defense that DOJ is there and part of their job is to defend, federal laws that were duly passed by Congress and signed by the president. That is their role. But, under this, not that they're the only administration to ever do this, but certainly much more aggressive about not complying with that vision of the DOJ through this first year in the second term. And so it does make these things where you would normally be like, well, yes, DOJ is defending this because that's DOJ's role. That's what they're supposed to do. It makes it more questionable when that's not what they're always doing all the time in other cases. And so yeah, you could look at them and say that this is DOJ defending the federal law like it's supposed to do, but it becomes harder to make that as the justification as the administration acts to break norms, that exact norm in other areas.
Yeah, well, and if you look at the text of Donald Trump's order on the Second Amendment that he issued back in February, I mean, it does direct the DOJ to examine not just state and local laws, but policies of the federal government, the positions that the federal government had taken in Second Amendment cases. That was part of his directive as well. And so it is concerning to me. And I would like to see. Again, I'd like to see more transparency, and I'm not blaming Harmy Dillon or even really Pam Bondi. I guess the buck stops with her. But I think that there does need to be an honest explanation and a willingness to talk about this, with gun owners and Second Amendment advocates. Why are you taking the position, or why are these attorneys taking the position they're taking? Is there any pushback happening in Main Justice? Is there any, what is the process of deciding what position the DOJ is going to take in these cases? We don't even really know what that process looks like. And there's no reason to keep that sausage making secret, right? I don't think anybody benefits from that. I think a lot of people would benefit from actually knowing, like, all right, this is how the DOJ comes to these decisions. This is why we see the DOJ staking out these positions.
Yeah, certainly would be very interested in hearing more from DOJ on why this dichotomy seems to exist.
Yeah, absolutely.
We've been covering. But real quick, just to the last thing I wanted to get to, as I alluded at the beginning of the show, is this week's episode was meant to be an interview with the CEO of Grab a Gun, which is newly public gun retailer, online gun retailer, and I had somebody that you've actually had on your show before as well. So, and you're also a reporter journalist here, and I want to get your view on it real quick. And I want to just inform the audience of why that interview didn't happen. So we've been going back and forth. I've been going back and forth with the PR company that represents Grab a Gun. They had offered to have the CEO on. I said I'd be willing to do this if we, I'd like to have a conversation about grab a gun versus the state of the overall industry. And I'll just give you a quote from the email I sent them. Don Jr.'s investment and the recent TPUSA promotion that they did, and then the rarity of being a publicly traded gun company. Those are the topics I wanted to focus on in the interview, because that's what I find interesting about grab a gun, right? We only have two publicly traded gun makers, Ruger and Smith & Wesson, and grab a gun's actually the only publicly traded gun retailer,
Yeah.
in the country. So interesting on that front alone. We get to see their earnings reports every quarter, and we got a little bit of insight into the industry. People don't realize how small the gun industry is, really. I think like the bubble gum industry is larger than the gun industry. Only one gun company's ever had a $1 billion year. I think it was Smith & Wesson had one once during the peak. So like it's a smaller industry than people understand, just because it's such a prominent part of American culture. But guns are non-perishable items, and they don't go bad. So you don't need to, even if you own a lot of them, you're not buying 100 guns a year for the vast majority of people. Anyway, and then obviously grab a gun has the aspect of being involved with the Trump family, Don Jr. in particular, because he's one of their directors and he rang the bell when they went public. So that aspect of being tied to the president's son, is going to bring greater scrutiny to what you're doing. But also, just like, I find it interesting to see a major gun company being that politically forward, I guess, or like making the politics of this stuff part of their brand. You don't see that a lot from gun companies. Certainly not the biggest ones, right? You're not getting a lot of political talk from gun companies. Really, they don't even like to talk to, I don't know your experience, but they don't usually respond to comments on even about lawsuits that they're involved in and stuff like that.
Yeah.
So it's, I think it's a, not that they're, I don't know. I don't want to like grab a gun. And this is where we're going to have more of a conversation with the CEO to kind of get this idea of, why get involved with somebody like Don Jr. at all? Why, like, how is it benefiting the business? I assume it is, right? And the TPUSA promotion is another aspect of that, because you don't see a lot of direct promotion of political groups outside of like just straightforward gun rights groups. And I assume that there's positives to, like, there's probably drawbacks to, you alienate some people, but I assume you're bringing, like, they do it because they think it's bringing in more people than it's alienated. I'm interested in that whole conversation. But anyway, so they emailed me back. At first they said yes, and they scheduled, and then the day before the interview was supposed to happen, I got an email from Keel Decker, who's one of the PR people at this company that represents Grab a Gun. They said, Mark, the CEO, is looking forward to the conversation, but would prefer not to spend too much time talking about Don Jr., as he doesn't want the interview to get bogged down with Trump-related things. And maybe we'll just have an open conversation here about how we handle interviews. But for me, the reason that I emailed back and said, no, like I can't agree to changing the interview, especially like the day before, the questions. This wasn't quite the level of like, send us your questions so we can approve them beforehand. That would be an even more bright red flag.
Yeah,
right?
that's just a hard line no, right?
That's a common. I don't know how many, what people understand about journalism and interview ethics here, but sending approval of questions beforehand is absolutely one of the red lines in this business, I think. Sending topics is like, you want to be able to, for people to understand what you are going to be asking about.
Right.
But to me, like, it felt too close to that line of just like that. I think they were making it clear they didn't really want to talk about the political side of the company at all. And look, that's their prerogative, right? They don't have to do interviews on that stuff. But I didn't think, like, the timing, the day before the interview is supposed to happen, I think is at least a bit rude, if not something worse than that. But yeah, when I said no, I wasn't willing to change like the topic of the interview, or at least cut out or significantly reduce, the section about Don Jr.'s involvement. They said no to the interview, and that I told them they have an open invitation to come on. Like, it wasn't. I'm not here to try and ambush anyone, any of our interview subjects, but I also don't want someone to dictate, I guess, the terms of what the interview is going to be. So I don't.
Yeah.
You've had them on. I don't know, what was your experience like?
It was okay. I mean, in all candor, and I apologize if Mark Namani is watching this, but I didn't think it was a great interview. Sometimes when you talk to, I mean, I guess it can happen with anybody you're talking to, but it just, felt like there was not a lot of insight. I don't feel like I walked away from that interview with a lot of new information about, why Grab a Gun was, doing what they were doing. It's been a while, so I honestly can't remember if he, deflected on any of the Trump stuff. Um,
Yeah,
I will say that, again, like, you're not an adversarial journalist. Like, you're right. You don't ambush people. Like, there's a part of me that thinks, all right, if I had gotten that email, I just would have said, all right, duly noted. And then I would have asked whatever questions I
yeah,
wanted anyway.
right.
But
That's fair,
um,
and
but I don't know that I would have, right? I mean, like, that's my knee-jerk reaction. But you do that, then you burn bridges, and maybe,
yeah.
the next time you try to reach out, then they're like, "Well, go to hell. I don't want to talk to you." We felt
And
like we
I'm sure
were.
they won't be happy about me bringing this up, but they and I, like I said, is there I emailed them back when they said they weren't going to do it, and I was like, is there anything more you want to say to explain why, like, you guys don't want to do the show? Because I'm going to talk about, obviously I'm going to
Yeah.
discuss this. And look, like I said, they didn't try to ask for questions or whatever, but it just felt like they were trying to shape the interview too much for me. I do think it's odd to have Don Jr. as like one of the faces of
Well,
your company, and then not
that's
want
the
to talk
thing,
about
right?
it.
Like, you've got to expect. I mean, he is a public-facing part of that company. And so you've got to expect that even if you're Mark Namani and you're not Don Jr., that Don Jr.'s involvement with Grab a Gun is a legitimate topic to bring up during an interview, right? Because he very clearly is a publicly facing part of that company, right? I mean, he's out
I
there
would think
talking
they'd
about
want it brought up.
Grab a Gun. I
Yeah,
would.
I mean, why be involved if you don't want people to talk about? Like, he's the most famous person involved with their company.
Right. So,
He's maybe the most controversial too, but like, still.
yeah. But I mean, listen, I think, it was well within your wheelhouse as a journalist to say, yeah, I'm not really comfortable with you trying to shape the direction of this interview. And obviously it was well within their purview as a corporation to say, all right, well, we don't really want to do this interview thing because we're not sure how it's going to go.
Yeah, and
Disappointing.
look,
But
I don't want to be uncharitable to them, because like I just read the reason they gave, and so people can judge for themselves. To me, it felt it felt kind of insulting, because it felt like what they were doing was, maybe they're used to working with influencers who have different standards for this sort of thing. Um,
I think there's a
and
lot of that going around the media in general too, right?
yeah, I
And
mean,
yeah, and look, the media ecosystem in which we all operate. If you don't want to face tough questions, if you're afraid of facing tough questions, you don't have to.
you
There
can
are
avoid
plenty
it.
of influencers out there who will, they'll say, okay, that's great. Just give me access to you, and I'll let you know what the questions are going to be. Right? There's a difference between journalism and reporting and just talking to somebody, right?
Yeah,
And not every one of the interviews that I do on Cam and Company is like hard hitting journalism. A lot of what I do is just conversations,
sure.
but again, if it ever got to the point of like, hey, we'll come on, but you're not allowed to talk about this. Like, I didn't have any. I'll tell you, like, when I reached out to DOJ by getting Harmy Dillon on, there was nothing like that in the response. Again, they wanted to know, like, do you have anything specific you want to talk about? Just so we can prepare, And I said, well, yeah, I think we're going to hit this, this, and this. But they didn't come back and say, well, could you avoid this? Nothing like that. And if they did, then I probably would have said, no, I can't. I can't
Right.
promise you that. So
Right.
I think that, but as I said, in this environment that we operate, if you're a company or you're a CEO or you're an advocate and that makes you uncomfortable, there are unfortunately for reporters, and I think unfortunately for people who crave real news, there's no shortage of people who will help you circumvent tough questions out there.
Yeah. Yeah. And I agree. I absolutely agree. And I feel like maybe they're more used to dealing with that. But and that's what I felt like they were trying to do is like, no, let's not talk about this Trump stuff. Because it could get controversial or it could get me, a have a bad clip of our CEO
But
out there.
no such thing as bad press, according to P.T. Barnum, right? So
Yeah, I mean, yeah, and you think being involved with the Trump now, they certainly have capitalized on that concept over
well,
their
absolutely.
entire,
I
careers.
mean,
So like,
I got to be honest with you, Mark Namani coming on this podcast, and even if you had spent the entirety of the interview talking about Don Jr.'s relationship to Grab a Gun, and no offense to you, Steve, I would say the same thing about Mark Namani coming on Cam and Company. Don Jr. appearing on stage at Turning Point USA talking about Grab a Gun, that's going to have a much bigger impact in terms of on Grab a Gun than you or me or frankly any podcast beyond maybe like Joe Rogan or Nick Fuentes that Mark Namani would appear on. And I'm not saying Mark Namani would go on Nick Fuentes' show, by the
yeah,
way.
hopefully not.
Mark,
I don't
please
think
don't
he
take
would.
it personally.
Given that they don't want to come on this show, I don't think they would. They seem to be avoiding the
I would
controversy.
hope not. Let's hope not.
Yeah,
Yeah.
certainly not. Then I would hope that he would not be CEO anymore after that. But regardless of this hypothetical,
I didn't mean to open up that can of worms.
but yeah, I mean, it's just, but I feel like I have to. One, I want to be fair to the guests and be upfront. Like, I'm going to talk about, like, I wouldn't talk about Grab a Gun if it wasn't for the fact that it's publicly traded and it's involved with Don Jr. Like, it's just, there are a million online gun retailers out there. There's some that I have, like, that I've ordered from the past, Gallery Guns and Bud's Guns. And we do gun business coverage here, but it's not all gun business stuff. And so it has to be something interesting to the company for me to have the person on. It's just what is interesting about Grab a Gun is, well, I mean, that what you just talked about there, like Don Jr. talking at TPUSA about Grab a Gun, uh, presumably would actually help their business a lot, but also it silos them into being a specific, you're only targeting a specific audience, and you're going to turn off a lot of people by doing that too. And I'm interested in, like, what are they seeing in terms of the effect of that, of being more politically forward. Although here it feels like they don't want to be, because they don't want to talk about any of that. And that's a little strange too, right? To see that, to be fair, and if I don't know, maybe because you interviewed him, but if Mark comes from a more traditional gun retailer background, they do shy away from being viewed as extremely political or like heavily political outside of specifically about gun rights. You know
I
what I
would
mean?
have to, again, it's been several months since I interviewed Mark, but if I'm not mistaken, I'm not sure that Mark actually has much of a background in the firearms industry at all. I remember when we talked, he talked a lot about, and he really seemed to be excited about the coding, the proprietary
Yeah.
coding for Grab a Gun, right? And so
That's
I
in a lot of
said,
their marketing and investor material, is their ideas that they set themselves apart by being like more technologically advanced and more cell phone friendly, and that's how they're differentiating themselves.
yeah, okay.
Um,
So this is from Grab a Gun's website. As a software engineer by training, Mr. Damani has pioneered ground up software solutions for virtually every business process, enabling Grab a Gun's highly efficient scalability. So I think, I think Mark Damani is a gun owner, but I think, his background, again, is in tech, right? And so
yeah,
I don't know if that helps explain anything. I can't speak
yeah,
for Damani, but
right.
But yeah,
Um,
I will say if he's listening, Steven will be fair. Come on the show. I don't think you got anything to worry about.
sure,
That's my
yeah,
that's my opinion.
and look, it's an open invitation. I do find Grab a Gun interesting, but interesting. I mean, and look, I'm interested in the idea that they also have maybe cracked some sort of advantage on the tech side. I'm very skeptical that that's the case. compared to the other gun retailers that you can go on. Like, is Grab a Gun actually significantly have some advantage there? That's I don't know, but I would be interested in the answer. And then also, like, I mean, I don't even know that the politics side is the most controversial thing about them. Like, they're publicly traded because they went public through a SPAC, and their stock is down like 60% since that happened. And SPACs have a very bad reputation since 2020 for how they perform. So there's also like that, there's
But
the
then,
business side of it is interesting too,
what, yeah,
not necessarily for positive reasons.
and kind of going public at a time in which gun sales are declining.
Yeah,
Like that to me would be an interesting line of conversation too. Like, how do you launch a publicly traded company in the firearms space at a time in which it's not a great time for the firearms industry? What challenges are come with that?
yeah.
But
And what did the insiders make a bunch of money off of that SPAC IPO, only to have the retail investors, down 60%? Like, I'd be interested in. I don't know. I'm not saying they did. I know that that's been one of the problems with previous SPACs, and they do seem like they are perhaps doing a little bit better in the last quarter. We wrote about their earnings, and they were um, there were some positive numbers in there. I think overall it was a dark picture like the rest of the industry right now. But I don't want to prejudge the company or anything like that. I do think there's just a healthy conversation to be had, and that's what I would pursue on all these fronts. Like, I'm not going to not ask certain questions or not bring up a topic if that's just not. I just couldn't do it. You know what I mean? Like, it's just it's too close to the idea of certain questions being off limits, and then why am I even having you on? It's because those are going to be the questions that everybody wants me to ask. You know what I mean? So they didn't go that far. I don't want to. I read the quote earlier, what they actually said to me. It's their prerogative, and I tell them the topics. If they want to come on, they do not have to. And like you said, a lot of times it's easier to just go to a more favorable ground where you're not going to have the potential of facing negative inquiries like that. But hopefully they'll change their mind. I mean, they're willing to do your show. You also are somebody who I don't think is willing to shy away from tough questions. So maybe they just got cold feet on this one. But I figured it would be honest to explain why this interview is not what it was originally going to be. So
well, I gotta say, I'm not unhappy that it worked out that way. From my perspective, was like I said, I love hanging out with you and spending time with you. So anything
yes.
we get to join the Reload podcast, I'm glad and grateful for the opportunity.
And I think the DOJ news was actually is bigger news anyway, to be frank with you. While Grab a Gun would be more interesting, just general topic conversation. We had real current events that I think were worth covering. So I appreciate you being able to do this. And I hope you had a Merry Christmas. And I hope that the new year is better to you, and that we will get to do a lot more of these episodes, and that we'll get to see each other in person. It's been a little while since actually seen you.
It has been. We'll have to talk about Great American Outdoor Show off here. I'm not going to be at SHOT Show this year, so I think Chaos might be my first opportunity in 2026 to leave the farm and go out and do some on the ground coverage of Second Amendment stuff. So we'll
Absolutely.
see. But yeah, man, I like I said, always appreciate the opportunity. I'm glad that you had a very merry first Christmas with your beloved, and I hope that 2026 is a good year for you and your family and all of your listeners. And yeah, me too. And look forward to talking again very soon. Maybe even on Cam and Company next week if I can
Hey,
you
yeah,
on Monday or Tuesday.
those are the days that would work for me. So hopefully we can make that work out, because I would love to get back on Kim and Company. I am we're going off on our honeymoon / my sister-in-law's wedding in Europe. So I've never been to Europe. We're going to Paris, and then we're going to Zurich, Switzerland, where my sister-in-law is going to be getting married. So looking forward to that trip. But that starts the end of next week. So hopefully, I'd love to jump on at the beginning of the week if we're able
Uh,
to.
we'll make that happen. Yeah, enjoy the French snails and Swiss chocolate. Don't do the other way
Mm,
around. Swiss snails are gross. French chocolate's but yeah, we'll touch base, and we'll definitely try to get you on one day next week. Thanks, Steve.
awesome. Sounds good. All right. Well, that's all we've got for this episode. If you know Cam, you can find more of his work over at Bearing Arms and at Cam and Company on YouTube and all the podcasting apps as well. Great show. And I would recommend listening to that full interview with Harmeet Dillon, because I think it's one of the only ones where she's like sat down with somebody who covers Second Amendment issues. So it's even just for that, it's worth it. So head over and check out all of Cam's writing and his show as well. But that's all we've got for you guys this week. We will see you again real soon.